not yet met, I'm David Meyer. I'm the dean here at the law school, and it's my great honor to welcome you to this 2025 Dennis Block Lecture in International Business Law. This lecture is a highlight of the life of course, our Block Center for International Business Law, but really of the entire Brooklyn Law School intellectual life. And tonight we have a very special program with our featured lecturer for this year, who's José Alvarez of NYU Law School, very distinguished scholar of international law, and we'll be speaking tonight on women's property rights under CEDAW, under the Convention on the Elimination of All Forms of Discrimination Against Women. Professor Alvarez is the author, co-author, with Judith Bauer of the European University Institute, of a new book, Women's Property Rights under CEDAW. And Professor Alvarez and his co-author find that in the convention there is, find in it very substantial potential to be transformative. The convention is an ambitious protection for the equal rights of women comprehensively, and sort of addressing patriarchal structures, stereotypes, intersectional discrimination in all forms, and the role that it plays in impairing the equal wealth and property rights of women. So it's a great honor to have Professor Alvarez with us, and especially on his birthday. So I want to, it's a sign of his commitment to scholarship that he is here with us on this evening, and so very grateful to him. And so to introduce our distinguished panel who are also joining us, I'm pleased to hand it over to my colleague Stratos Pais.
Thank you, Dean Meyer. Thank you, everybody, for being here, especially to Professor Alvarez and to our discussants. It is a real honor to have all of them here with us tonight. Professor Alvarez is the Herbert and Rose Rubin Professor of International Law at NYU Law School. He's written over 7 books, the latest of which he's going to tell us about today. He's also written 170 articles, which I guess is pretty impressive. But in my view, what sets him apart is his remarkable range in terms of both practice and scholarly contributions. In terms of practice, he's been a special advisor to the International Criminal Court, an attorney advisor to the Office of Legal Advisor of the U.S. Department of State, a judicial clerk, and a lawyer in private practice. In terms of scholarship, he's made contributions, major contributions, to the fields of international law, public international law, private international law, international investment law, international organizations, international human rights. And while many scholars write on different topics, Jose is unique, Professor Alvarez, is unique in my view in having left major marks in all of these different areas that he's touched. So thank you to Professor Alvarez for joining us. It's an honor. Thank you also to our distinguished discussants who are impressive scholars in their own right, who, in my view, also demonstrate a remarkable range of scholarly contributions and who are particularly well positioned, I think, to comment on Professor Alvarez's latest contribution. So Professor Eleanor Brown is a professor of law at Fordham Law School. She's a leading scholar of property law, migration law, globalization, development, and race in the law. Professor Marcia Garrison is the 1901 Distinguished Research Professor of Law at Brooklyn Law School. She's an expert on law and policy relating to families, children, reproductive technology, and medical decision-making. And Professor Darren Rosenblum is a professor at the McGill University Faculty of Law. They have also taught as a visiting professor at Brooklyn Law School, so welcome back. And their scholarship centers on corporate governance with a focus on diversity initiatives and remedies for sex inequality. So thank you to each of you for being with us today. We look forward to your comments. Without further ado, I'll hand it over to Professor Alvarez.
So thank you very much, and I'm particularly anxious to hear from the commentators. So this book was a product, as you heard, of two people. I hired a research assistant who then went on to EUI, and I asked her to take a look at the property outputs of the CEDAW committee, which is the expert body charged under the convention in particular areas. Initially, we couldn't find anything, but we stretched the search to include the general recommendations and not just the views issued by the committee when states had opted for the optional protocol and individuals can make complaints. And so we started noticing certain phenomenon. And so what I'll do here is I'm trying to limit myself very closely because I want to hear from the folks. And so the reality that we found is this, which should not surprise anyone. That is a reality of a gender gap in both property and wealth. And that gap is more like a chasm, frankly. My old colleague from Michigan, Catherine McKinnon, was not wrong when she said women are more likely to be treated as property than to have any around the world. And you can measure this by who has access to credit, who owns businesses, who owns farmland. Despite the fact that women produce a good chunk of it, they don't seem to own it. And when they own it, they are stuck with very small farms because they don't get the credit to expand their businesses. They're also stuck, as you know, with low-paying jobs, unpaid work, as in the home, or with respect to the care of as caretakers in the informal sector. And so that's the reality, and it's not necessarily getting better, despite the fact that gender equality is one of the SDGs 17 Sustainable Development Goals. Number 5 is gender equality, but the measures that we now have of the gender snapshot suggest that thanks in part to COVID, conflicts and all the economic consequences, including climate change disasters, which disproportionately affects women especially. Progress is extremely slow or non-existent on most of the indicators that are in Sustainable Development Goal number 5. And so the problem is huge, and we only briefly address it, but the solutions that we have include the World Bank, which has had a approach to property, much in rhetoric, a little less in practice. And when you look at the actual practice of the World Bank, much of it consists of what this picture describes: land titling efforts to get those yellow pieces of land titles into the hands of women, which is an admittedly important part of the show, but a relatively small part of the effort. The reason that it is important is suggested by Lanza, an NGO that's devoted to especially rural property and equality. And according to that slide, as you see there, all these countries have rather formal restrictions that make it very difficult for women to access land and especially to own it. That is, women don't have equal ownership rights to property to begin with in 15 countries, and then in 90 countries, the very bottom one, the customs, even though the laws might actually formally permit women, the customary law of various types inhibit women from having access to land. That's 90, 35 countries where widows don't have equal inheritance rights, 34 where daughters don't have equal inheritance rights, despite the numbers who work in agriculture. One of the problems that emerges from this, and the challenge that taints the literature here quite a bit, is that the World Bank's property ownership efforts have been seen with some justice as reflecting this book. To make it very simple, Hernando de Soto is a neoliberal type who published this very famous book, The Other Path, which is the economic answer to terrorism, in which he promoted and touted the Washington Consensus model, which includes prominently protecting property rights, but also deregulation and a variety of forms of globalization, whatever the impact might be, including encouraging investment flows. That has tainted I think more broadly than World Bank has, the idea that there really should be a property right to property. That is a human right, that is, to property. And so what we found, one of the reasons for the book actually, is that there was relatively little literature in the international human rights space about this particular right. There was far more emphasis on many other aspects of human rights, including on behalf of women, than on this. And we tried to explore the particular reasons, and the reasons also affect the CEDAW. That is, very few complaints are actually brought by women to the CEDAW committee, even though a huge number of countries have ratified the optional protocol to the convention that permits complaints. And when you look at the chasm and you look at the number of complaints filed, 17 complaints in so many years of the CEDAW is quite low. But what makes this jurisprudence much richer are the many general recommendations that the CEDAW committee has issued, as well as the hundreds of concluding observations issued by CEDAW in response to state reports. And that's what make up about 100 pages of the book. And then the other chapters, which I wrote, are basically what do we make of this, and how do we think about what women's property rights look like. The criticisms I will go into in a minute, but I think I will start by simply pointing out the actually rather surprising breadth of the concept of discrimination in the CEDAW Convention. And so here we're talking about de facto, not just de jure, that is substantive equality. It's not about making the laws formally treat men and women equally, but actually maybe you want laws that favor women and actually address specific structural features that prevent them from attaining substantive equality, even if the laws are formally equal. There's also direct and indirect discriminatory distinctions, often exclusions, practices, or omissions that also have that effect. And that CEDAW includes not just the specific rights included expressly in the convention, but by cross-references, anything that has that kind of violation of substantive equality as a result of fundamental freedoms recognized in the rest of the human rights edifice. So all this other economic, social, cultural rights, civil and political rights from other treaties can be brought into CEDAW so long as they have this discriminatory impact. And that CEDAW reaches not just the public authorities, but also private actors that need to be regulated, not just when they discriminate inside the country, but when they go outside the country. Extraterritorial application of the anti-discrimination laws when it's one of your companies. Usually at this point, private international lawyers leave the room and are shocked. But in any case, the other aspect of CEDAW that makes it unusual is the committee, through the convention, says you have to basically modify social, cultural patterns of conduct, elimination of prejudices, including inside the home, customary practices and stereotypes, religious groups, including polygamy, is not favored by the CEDAW committee, and states are urged to actually attack this in ways that would be fundamentally inconsistent with American values, I think. That is the notion that what we do inside the home is not just left to states, but certainly wouldn't be subject to federal regulation. This is one of many aspects of why CEDAW cannot be ratified absent a real revolution in U.S. law. So you may know that the U.S. is one of the few countries on earth that is not a party to CEDAW. Virtually every other country is. But these are the things they formally commit to. And lastly, of course, they back what we would call affirmative action. The end result is that, for example, through these broad measures, things like this are addressed. This is a widow in India, and in many parts of India, culturally, when you're unfortunate enough to lose your husband, you become a non-person. That is, all the property disappears, the male relatives come in and take the property, including any inheritance, and the women often end up by themselves in particular approaches to hospice that are for widows in India. So this is the kind of thing that, because of culture, many laws don't touch, but the CEDAW committee does and regards this as an extreme case of violation of CEDAW. And so what did we do? So what we did was we looked at the CEDAW's requirements to respect, protect, and fulfill. Those of you who are human rights types know that all three words are important, and it's not just that states themselves have to do this and can't violate the committee. It's also that they have to protect women from private companies and other efforts that end up in the same place, and that, if necessary, the states have to fulfill substantively, for example, a right to adequate housing if the private market doesn't supply, and that itself violates the rights of women, then the government has to step in. And so those three aspects, respect, protect, and fulfill, apply to the following categories: Social Security, maternity leave, other areas of social life, access to credit, elimination of discrimination against women in rural areas, and respect to Social Security, agricultural credit loans, technology, adequate living conditions in relation to housing. On this one, Article 14, even though it applies to rural women, the CEDAW has made no distinction and has applied this in urban areas as well, so that it includes a right to adequate housing, adequate living conditions in relation to housing, and I'll mention a couple of cases that deal with that. Equality before the law includes contracts, rights, and administering of land, and this one is a particularly sensitive area of all matters relating to marriage and family relations, same rights with respect to ownership, acquisition, management, etc., in the family. One of the touchiest, most sensitive issues across the planet, not just in this country. What this means is that we divide the book into property rights in marriage and family relations, civil and political rights, land rights, adequate housing, intellectual property and seed rights, access to credit, economic empowerment more generally, social benefits, and CEDAW has extended this to property rights that are the outcome of gender violence. So that includes access to the home, protection orders for women, even when the husband is the one that has the lease or owns the family home. So in a way, the CEDAW committee basically goes hostile to the World Bank's focus on land rights. That is, if the land rights are formally there but are not respected because you can't go to court, or if the access to the home is formally there but it's actually no protection order defends a woman, then the land issue, the question of the marketability of the land, the question of who has actually the formal right to own it, becomes a bit of irrelevancy as far as CEDAW is concerned. Nonetheless, despite what I've just described as, and by the way, we consider all of these things, even though the CEDAW committee doesn't cast them as such, as property rights, based on the fact that in most countries around the world, when you focus on these things, they become inheritable pieces of property. So that we're not just formally focused on this in terms of access to financial credit and not calling it property, but we think it's important to actually say this is part of your property law because it's so foundational to society. And so we were not just limited to what the CEDAW committee called it. And in fact, we interviewed some of the CEDAW experts who sat on the committee, and they were quite critical that we would call this property rights. And then in the final chapter, we explained why this is important to actually feel this way. Now, we address in chapter 3 many of the critiques of CEDAW. And this includes a leading feminist piece. Actually, I was the reviewer on this book, and I admire it greatly. They're both good friends, Hillary Charlesworth, who's now in the International Court of Justice, and Christine Chinkin, the 2000 book called The Boundaries of International Law. And they started a series of critiques, quite serious, about the CEDAW committee. This is what it looks like. And I would say that what we do in the book is trying to suggest that while there's a grain of truth in all of these can be nuanced if you actually take a close look at what the CEDAW committee has done since the convention came into effect. They do not consider the male standard to be the standard of equality. They don't assume an undifferentiated, essentialist woman. It is on a binary. That is, the convention is very much targeting women as if they were separate from men and only benefits women in the sense of against women is the test. It's not a discrimination convention that could be used in favor of men. They think the rest of the human rights edifice does very well on that score, whether that's true or not. But it also means that when you're outside that binary, it doesn't cover you, and I think that is a fair critique. The critique that it marginalizes women's rights and leaves it to one committee is unfair in one sense. That is, the very success of the CEDAW committee is in part the fact that it has had considerable pickup in other human rights forums and in national courts. So we have hundreds of cases where CEDAW is cited for the interpretation of a constitution, hundreds of cases where CEDAW is cited in the interpretation of a statute, for instance, far more than the almost nil, obviously, references in the United States, because we're not parties, but even if we were, I suspect there'd be problems. We can talk about that if you'd like. There's a critique that it's overly deferential to states substantively and as a matter of enforcement, and that's fair, and we can talk about some of the issues that we have seen, especially recently, as given the cutbacks in the amount of time, resources that the CEDAW committee now has in Geneva, and also the strength of states like China, who are trying to change how we address human rights in the UN. And rely more on, let's just say, managerial techniques and not the mobilization of shame. That is, China's approach is this is a win-win. We should praise countries when they do well and hope for the best. Otherwise, we can talk about that. So there's a bit of that backlash happening at the CEDAW. In fact, in some ways, we indicate in the book that the golden era of CEDAW's jurisprudence may actually be in the past and not in the future. This may be the high point of this jurisprudence. And I think it's also unfair to suggest, for example, that the committee, which does not mention discrimination as gender-based violence, the committee leapt over that omission and has actually concretely addressed gender-based violence, perhaps not as strong as it should be, but certainly is now part of the property jurisprudence that we're talking about. The bottom line of these critiques is that CEDAW is insufficiently transformational, that it does not really address the reasons women are subordinate in terms of economic rights or otherwise around the planet, and we are a bit more, let's just say the glass is half full approach to this. Other critiques we also address look like the ones that are inspired by the reference to the other path. That is, if you believe that the protection of property as a human right is basically protecting the morals of the market, as Jessica White's critique of human rights generally says, that we basically are only doing this. We're enabling neoliberal economic policies, privileging private property rights, encouraging commodification, privatization, deregulation, and globalization. That we are also entrenching market economies by ignoring the structural root causes of women's subordination, that we focus on the public sphere and we don't look at the responsibility of market actors for all of this, and we again privilege the Western women's approaches and ignore group rights and local moral codes, and we elevate sex over other forms of subordination. and it legalizes what needs to be political. Let me explain that one. That's a favorite among some of the critical scholars, which say, look, we deflect all this attention to these legalistic approaches in the CEDAW committee when we should be engaged in political transformation. And therefore, all we're doing is we're placating at the margins some women's rights and privileging some of them who are fortunate enough to get to CEDAW, come from European countries that have access to CEDAW, and ignore the rest. And we are making sure that the socialist revolution, toppling market capitalism, will never come. So that's one of the critiques, and it's also one that's embedded, I think, in the Jessica White piece. And that it internationalizes what ought to be the local. Local battles are important. We relegate everything to CEDAW and sometimes ignore what would be most effective. We argue in the book that based on what we see, there's plenty of evidence against almost all of the critiques I've just mentioned. And I'll just highlight, because we don't have time, some of the things that are in the views. That is, these are the closest to judicial opinions issued by CEDAW in response to complaints. And so these cases in Tanzania highlight widows' rights. The rights that I've just described for India also apply in Tanzania. And basically they said that all these customary norms by which the male relatives comes in and disinherits, in effect, women violate the CEDAW. We have adequate housing cases from North Macedonia. The cases in North Macedonia involve a series of cases by groups of Roma women who live on the margins of society. They live in shelters that were illegal to begin with, and then one day come home to find that the shelters were destroyed completely. They have no place to stay because a developer has been given land rights to develop that property. And what the CEDAW committee indicated was that forced evictions are inherently discriminatory given the adverse effects they tend to have disproportionately on women, and that those Roma women have a right to adequate housing, including, if necessary, provided not by the market, but by the government. And that adequate housing, in the case of many of these women, they were either young mothers or pregnant, had to be sensitive to their particular needs for access to medical care and so forth. So a full development of what the adequate right to housing would be in these marginalized communities, and also an acceptance that is quite characteristic of CEDAW of intersectional forms of discrimination. That is, these women faced complex discrimination that were because they were poor, they were Roma, they were women, and they were pregnant and unemployed. All of those things combined need to be recognized. In Moldova and the Netherlands cases, what we're talking about are government benefits or private benefits from private employers to pension rights, et cetera, that discriminate de facto against women because they don't come into play because the women were not formally employed because they were helping the disabled child or because they were doing other things for other relatives. They were allocated these responsibilities under traditional forms of what the family should look like, and that in those cases, the fact that those informal work was not recognized was a violation of Moldovan law, the Netherlands law, and that their pension rights should be restored. And then a number of cases that reflect this picture that I'm about to put up. This one is the reality. It happens to be from the US, which is not a party, but you may notice she has a black eye, obviously domestic abuse. She has had to work especially to get the money to change the lock herself on the door of the apartment because protection orders were not available. This is the state of Texas, after all, and therefore she had to take her own self-help to protect herself. So in the cases, many cases that we have from Hungary, Austria, Bulgaria, and so forth, we have the same types of problems. Domestic abuse, sometimes the equivalent of death threats, proven to the court, and yet protection orders either don't emerge, the cops don't show up, or so forth, or the court issues a protection order, but they are ignored, and that becomes part of CEDAW's critiques. So that gives you a sense of what the interpretation looks like, and then we draw broader lessons from this that help to respond to at least some of those critiques. Yes, the convention was flawed to begin with, but there's been considerable evolution of what that convention means, and that it turns out that recognizing property rights under this convention does not equate to the neoliberal agenda. This is not about commodification. This is not about making property more accessible to foreign investors. This is not about deregulating. In fact, much of what CEDAW is reimposing states' duty to regulate in favor of this. So this is the opposite of the neoliberal agenda, and that it does have a binary, but within that binary, there is quite a bit of recognition of intersexual discrimination and some forays into gay rights, for instance, so that now it's not just a question of someone being formally recognized in their heterosexual marriages, but the insistence that once the state opens the door to civil unions, that everything applies inside that concept. Nuanced positions taken on the public-private divide, and it is not true that the CEDAW committee ignores the root causes of discrimination. So if you want to show that, take a look at the Canada Inquiry Report on the causes of Indigenous women's discrimination in Canada, which is quite extensive in the structural features of Canada and Canadian courts and the history of Indigenous peoples in Canada, to suggest that this is not always a surface description, but a deep analysis, sometimes very hard one, of the consequences of markets and capitalism. It's also the case that it also addresses marginalization, subordination in broader ways. And then I would suggest that there's no reason to think that this level of scrutiny from above at the international level is any less necessary now than it was before. Yes, some laws at the national level have changed, but when you actually look at their implementation, there is as much need now for CEDAW to actually take a look through shadow reports of NGOs, which tell us a bit closer to the truth of what is actually happening. So all of those are the big draw lessons. And then we admit all of these problems, so that, I think one of the comments was, with friends like these, who needs CEDAW defenders, because we are quite candid on all of this. That is, I think CEDAW can do better on all of this, especially the fact that when it gets to general recommendations, they're quite transformative, but it is not clear that they apply those case by case to their concluding observations when they criticize a state right in front of them. And often, they are quite content, it seems, when the state, 9 years later, after 2 reports, reports the same thing, to basically adopt a same kind of concluding observation that says, China, you need to do better. And so my frustration there, and led to some differences between me and my co-author, which is why, by the way, in the preface, because of my co-author's disagreements with all of my conclusions, she wanted to be clear that she was the author of only chapter 2, and that all the rest of it was my fault, right? Which is also why she's not here. But in any case, I basically don't think that examining human rights regimes or international law should be confused with celebrating either one. I think we have to be candid about it, and there's plenty here to criticize. Not all of it the fault of the committee. It is embedded in a UN system that denies it access to enough resources, limits by word count how many words can be allocated to a general recommendation. Also, it's the UN that pretty much decides admissibility, whether something actually can come before the committee. And so here we don't have time to talk about these critiques, happy to talk about this, but one of the things are jurisprudential. So the committee acknowledges that in some cases, the state has a right to fulfill the obligation. So there's a sufficiency point. That is, you state have to provide adequate housing, but it is not very consistent on what that means or what sufficiency is, how close is that to discrimination. It is also not clear with how it handles intersectional discrimination. It is not just adding up the numbers of forms of discrimination. There should be some connection to some basic ideas of why this particular accumulation of factors, identities, roles, ends up being more serious or less serious. And there's also a question of priorities. That is, assuming states can't do everything, I would think that threats to women's lives because of discrimination should be sort of up here, and other things less. The committee refuses to prioritize, and that seems to be a big no-no to actually prioritize on the excuse that all human rights are indivisible and should be given equal rate, which only an academic could possibly defend. And then there are the institutional challenges. I've mentioned some of these, especially now, sovereign backlash. And the book spends a great deal of time with comparing property rights under this regime to my other area that I have spent an inordinate amount of time writing about, which is investment law. So this is I think, one of the few pieces of scholarship out there that actually ask whether international investment law is gendered. Answer, yes, but not only that, but that the concept of what property is in the two regimes are 180 degrees different. And therefore, I think it's fair to accuse international investment law of being a tool of neoliberalism, with some reasons why that may be a good thing, but that is not a fair accusation, I think, of the CEDAW committee. But we have an awful lot of these property regimes. I would argue that the defense of property is the most commonly enforced human right on the planet. It just may not be what you would think is human rights friendly in many contexts, but in the CEDAW committee, I think it comes closest to being faithful to what the actual object and purpose of this treaty is. And then the pathologies that I could talk about that came out in part because of our interviews with the committee are also in the book. And then we end on a hopeful note that suggests that one of the reasons that the CEDAW committee and its jurisprudence is important is that it doesn't stay in Geneva. That is, it travels. It goes through the byways of activists and others. It shows up in national courts. It shows up before national legislatures to reform laws. And even if the consequence is one change in inheritance rights in country X, that still could involve thousands of women who are benefited. So the idea that we should be content with not going legal because maybe someday we'll get a political revolution basically suggests we're content with the immiseration of women because someday we'll get the socialist revolution. I'm not sufficiently academic to defend that. And so we have legal compliance also extends through policy instruments like the SDGs, and these are some of the other hopeful signs, including, I think, an idea that the CEDAW committee gets from South African constitutional law that forced evictions are themselves violations of substantive equality, and a redefinition of what constitutes tenure security, including in the home, and therefore prioritization also of women's equality over what would be seen in many places as sacred family unit, and to bridge divides between international regimes, so that we end the book with a comparison of the CEDAW and the property protections that actually exist under the civil and political rights, which actually don't protect property as such formally, but when you look at the discrimination cases in the ICCPR, many of them are actually about property. And I think that there's the prospect anyway of that committee learning from the CEDAW committee, as well as economic, social, and cultural rights. And what we hope to launch with this book is comparative property jurisprudence at the international level, because I think there's been relatively little attention to what economic empowerment of women, but not just women, are all about, and what we do when we protect property through international law. So thank you for listening, and I look forward to hearing from the folks here. So I don't know, how do I turn this off? Oops, nope. This is just in case somebody raises questions. I love Virginia Woolf.
So first, it's a pleasure to be here, and it was a pleasure to read the book, which really does do a fantastic job of putting together a very large body of CEDAW jurisprudence, making it understandable, and describing its nuances. And I also want to compliment the authors on dealing so well with the criticisms of CEDAW and showing where they ring true and where more often they fail to provide the kind of nuance that we need. So I don't want to deal with any of that. Instead, I want to raise a couple of other issues where I would have liked to see the authors in the future go further. And one of them is this question about whether it's fair to look at CEDAW through a property lens. As José and his co-author note, CEDAW isn't about property. Its aim is to end discrimination against women. So the property protections in CEDAW itself are few, and CEDAW rarely relies on a property framework in trying to advance women's rights. So there's a fundamental tension here between trying to use CEDAW to look at property, and I'm not always sure that it works. Sometimes when we're talking about social benefits, housing, maternity leave, I think this is a really interesting and fair comparison. Sometimes when we're talking about areas of new CEDAW jurisprudence, like domestic violence, I'm less convinced that a property focus really works here to capture what CEDAW is doing or to tell us anything about property. So I do think this tension is interesting. And this future project, I think, is one that we should all pay attention to. CEDAW here perhaps offers an interesting backward window in that I'd be interested in knowing more about what an equality focus might tell us about the limitations and the concept of property as it advances human rights. So that's one set of issues that I would like to hear more about. The other are more practical. Most of the time, although there is agreement that CEDAW has some enforcement problems, there's what I guess I would like to see more here on the practical impact of CEDAW, which is actually quite controversial. CEDAW itself, why does the committee keep reiterating the fact that in its concluding operations, Country A has not failed to do anything that it was supposed to do in the last 3 country reports? It doesn't have anything else that it can do. CEDAW, like all of the UN conventions, lack effective enforcement mechanisms. They're shame and blame regimes, and the evidence is very thin that they actually have a lot of impact. The most recent analyses conclude that it's at best marginal, and that where it succeeds best is when the committee is more actively involved with a country. But CEDAW has limited capacity to affect those frequent interactions with states because it's up to the states to file reports with CEDAW, and many of them are way, way behind. They go years in arrears. So these kinds of practical difficulties in using CEDAW, I think, limit the extent to which its jurisprudence matters. And there again, I'd like to really hear more about how we might make sense of all that.
Thank you. Maybe we'll hear from all the discussants, then we'll come back to you.
Oh, don't expect answers. I'm here to learn.
So I'm really grateful that I was invited to join this panel, and it's super fun to read this book. It's an engaging book. I think the core argument is incredibly creative. I myself have not worked on public international law basically since I wrote the piece which critiqued CEDAW in 2008. My critique at that time was that CEDAW did not properly address the cause of discrimination against women, which is actually discrimination based on gender, and that it should have included men in the conception of CEDAW as well as other sexes, and that its focus on the binary was fundamentally problematic, both as a matter of fact, but also as a strategic matter in excluding the people who have the power to make change, which is men. I still feel that way, but I actually, while a lot of the other people that Professor Alvarez and possibly his co-author reference as criticizing CEDAW as being too far to the right or reinforcing a neoliberal focus, I actually really fundamentally buy your argument that CEDAW is not a tool of neoliberalism because, as you note, the property regime is extraordinarily different from the way the private sector operates. Since I wrote that piece, I've been working on gender equality and other forms of diversity within corporate leadership, and I've turned my attention primarily to the private sector because it has this capacity and power to affect change that I found a little frustrating in international law, as you noted. But that power, I actually see a remedy, as you do, Jose, in CEDAW, in thinking about property rights as a legitimate form of recourse. One of the problems, I think, genuinely speaking, on the left is a focus on identity-driven rights that are about discrimination rather than the distributive effects of discrimination. And property, as you note, is a particularly salient, if not the most salient, piece of inequality out there. I don't know if they've updated the numbers, but at least in the 80s when feminists used to talk about property instead of just other identity things, the statistic was that men own 99% of property in the world. And frankly, given recent trends in terms of the concentration of wealth in the hands of male oligarchs, it seems like that trend has only accelerated, if anything. So to me, it seems like CEDAW's potential is indeed, as you assert, revolutionary. It does not remedy the problem of the binary or the problem of getting men to jump on board with the cause. And so I still feel like those critiques of mine are still present. But I think the book does a phenomenal job of sort of calling out the left on its critique of CEDAW. On to your sort of unique engagement of the connection between investment law and CEDAW, which I think is probably a thing that unites the two of us against the entire world, that we both think about gender and private property at all. I think your chapter 5 on that is pretty brilliant. It does a great job of methodically comparing the two regimes and talking about the way in which investment law does a much more effective job of imposing remedies on parties. One thing that I thought was fascinating, which I learned about CEDAW from your book, is that the remedies CEDAW can impose actually do take into account the material circumstances of the party against whom the enforcement will be made. And that is, in fact, a pretty radical thing in and of itself, because the Anglo-American legal regime is, which governs contracts and corporate law, is basically too bad, so sad, right? If you've lost on a contract action, you're responsible for all the damages, regardless of your capacity to afford those impacts. And that reality is a tool that the wealthy often use against weaker opponents in court in order to render them incapacitated to challenge them. And I think that differential is indeed, as you suggest, a very gendered one. So in short, I think you've done a great job of bringing new life into CEDAW by focusing on its redistributive capacity to affect real change that will impact a lot of people who are suffering from immense inequality still to this day. And I'll add to my note a moment ago about the 99% in property. You know, in the past 20 or 30 years, we've seen huge adjustments in terms of wealth in both China and India of the poor, but the gender nature of that wealth disparity has not shifted, right? So your critique and focus, I think, is impressive and important, and I thank you for the book.
So, can you hear me? Let me, because of the videotaping, although my loud Jamaican voice really doesn't need amplification, but so I'm delighted to be here. Professor Alvarez, I love the book. I love the work. Everything that is said here is said from the perspective of a friend. So please take my comments in that regard. So, so I am not an international law scholar. I am not a family scholar. I'm a scholar of property and migration. And that very much affects what I see today. I had the great privilege in my last year of law school of taking a seminar with Owen Fiss and George Priest of blessed memory on Hernando de Soto. And they had gone down to Peru, and they had spent time at his institute. And then they came back to Yale Law School and they designed a seminar. And I was one of the early students who took that seminar. And it had such an impact on me that one of the classes I teach now is a seminar that is in part influenced by having taken that seminar. Now, the reason that I tell you that is much of what I'm going to say here is going to be a reaction to De Soto and the neoliberalism and his, in my view, failure to really take the challenges of gender seriously. I had not spent a lot of time on the convention. One of the wonderful things about this panel is that it forced me to do that. And I must tell you, I am completely convinced by the view that what CEDAW does is much, 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 much more than I had anticipated. Forcing myself to read the Tanzanian piece, to read the piece with the Roma woman. I mean, it's astounding. I mean, it's particularly in the current moment that we're living in. It really is astounding. So I am recognizing that. Now, so let me say the following. The way I come to this, I have a piece that I have worked on, which is not yet in the public domain, which considers why it is that when you look at gender equity in the developing world, the Caribbean, which is where I come from, does far better than most countries in the developing world. We're not Finland, Sweden, but we are, much closer than one would expect. Now, why is this? My view is that the real difference is that in the Caribbean, there's far less need to do reparative work on the basis of gender than there is in other places. And that is because women in the Caribbean got cash, and they got cash early. And having done that work, it influences a lot of and I'll just tell you very quickly how it is that they got cash. We have a very similar background to the U.S. South. Plantation slavery. The cash crop in the U.S. South was primarily cotton. The cash crop in the Caribbean was primarily sugar. The British, not out of any sense of justice, but just out of pragmatism, wanted to figure out a way for the enslaved people to feed themselves. They allocated land at the edge of the plantations to heads of households. They said, grow what you eat what you grow. If you don't grow, you won't eat. That turned out to be our version of 40 acres and a mule, because at the time that slavery was abolished, which is several decades before it was done in the United States, much of that land ended up in the hands of the people who were working the land. Plantation owners, because they were focused less on gender than on who would feed the children who were also enslaved, were allocating land to women far more than one would anticipate. And there were also contract rights alongside these de facto, not de jure, property rights, because people could go to market and sell and bring in the traditions of our West African forebears. If you spend any time in a market in Cameroon or Nigeria, you'll see this. Women handle the money. They sell in the market. And so Caribbean women were handling money early, right? So entirely inadvertent, I call it inadvertent institutional design. Caribbean women who were enslaved ended up with cash that was not the case in other situations in which people were enslaved. And you see that in our societies today. So because of that, I'm very focused on cash. Who is getting cash where? Okay, now the fundamental problem, which I think CEDAW does a lot more to address than any previous framework, but still not enough, is that for poor women in developing countries, what they have is labor. That's all they have, labor, okay? And, Amartya Sen has a quote that I love, that for most of humanity, virtually their only significant endowment is labor. And that is even truer of women, okay? Now, most of this labor is utilized in the home, okay? So, there are multiple arrangements. Some marry, some do not marry. Some utilize processes to get themselves out of familiar arrangements that don't suit them. But typically, we're starting in the home with women doing labor that is not compensated in a market sense, okay? So I'm very, very sympathetic to the kind of Jessica White morals of the market view. Now, traditionally, and I'm thinking here of Becker and his model, is that you look at a home, you have an altruistic head of household who controls the resources and acts in the best interest of the family. Okay, clearly now, we're beyond that. It has been widely criticized for assuming an altruistic family head. A much more realistic model, also subject to critique, is one in which, and this again is lots of saying, in which he calls it a modified cooperative conflict paradigm, in which members of the household face two different types of problems, one involving cooperation, i.e. how do I cooperate to get more resources for the household, and the other is dividing the total resources available among members of the household. Now, Sen's work is very influenced by India. I'm very glad that you spoke about India. And looking at rural Indian women. And his evidence is very systematic. It's very clear that women's contributions to the households are systematically devalued. And they receive less. They eat less. They rest less. On every front, they're getting less. Now, what is very complicated about this, and this I think is the fundamental problem that we have to address, is historically we have equated women's well-being with their perceived interests, and the emphasis is on the word perceived, okay? Now, here is the problem, and I think it's a problem for family law generally. I'm not saying I'm a family law scholar, but it is particularly a problem for the women that CEDAW is trying to reach, who are poor women. In that, if you're talking about perceived interests and perceived contributions, the question becomes, who contributes more to the family budget? Who spends more? And the issue in Sen's view is that irrespective of what a woman may perceive her interest to be, objectively, when they measure it, she is getting less than she should be getting. So she may perceive that she's getting a reasonable amount. And this is a very, very big issue in the Indian subjects that he studies. But when you objectively measure what they get, it is far less. Okay, so women in the household are feeding female children less. They are educating female children less, and they are the people actually doing it. Now, if that is the background, you then say to yourself, how do you, when the subjects who are receiving less are themselves often the people who are enforcing the norms that lead girl children to get less, how do you move towards a position of equality coming out of that? Now, the fundamental problem, I think, not just of international law, not just of the convention, but of law generally, because we have a person who has been wronged, a person who has done the wrong, and then we have a framework in which the person who has been wrong gets compensation from the person who has done the wrong, is that it's not well suited to that sort of scenario, right? And so I think my critique is less of CEDAW and less of you than it is how do we come up with a framework that can deal with that fundamental problem, which in my view is reparative, and to which I think we have very few answers. The last thing I want to say is that the way I think about this is, and I don't mean to kind of overutilize this Hirschman framework, but the question I always ask myself is, if a woman wants to leave, what is her capability to leave? Voice, exit, loyalty, right? Her ability to leave, and by that you want to do is to strengthen her bargaining power so she can say, I'm getting the hell out of here, right? Irrespective of what you think. And so what we're trying to do is to put resources in her hand that give her a credible threat of exit, right? Which too few women in this circumstance have. The thing that I liked about the Roma case is that, these women's homes had been destroyed. They were pregnant, many of them, and the committee said, this is problematic. They need homes. Now that, in my view, is putting resources in the hand of somebody so that they have a credible voice and they have a credible. So I am simultaneously saying not far enough, but much better than I anticipated. And the framework, I think, needs to be fundamentally reparative to get into the family space. I saw much more of that here than I anticipated, but still not enough. As I said, less of a critique of you than it is of the broader project. And by the broader project, I mean CEDAW and what the committee is doing. So thank you very much. Yeah.
We're actually past time, but I think it'd be great to hear some very useful comments from Mr. Alvarez.
So this was marvelous comments, and I can start with the last, which is one of the challenges of gender equality is precisely the fact that depends on the tool. So if you use international law, you are stuck, as you point out, with the fact that the very entity that needs to be reformed is in charge of the hen house, right? So international human rights law is built by states, partly to continue benefiting states. The same can be said of international humanitarian law. It makes war possible, palatable, by having rules on how you conduct warfare so that it is relatively humane and your population doesn't feel so bad about what it's doing to others, etc. These are critiques of David Kennedy and others, and they're totally fair on international law as a whole and international human rights in particular. I totally agree with them. And so what I didn't articulate enough, and maybe we don't say enough in the book, is that the whole framework for addressing gender equality has to use more than one tool. International human rights law and international law is only one of them. When I was asked by OUP to do a blog post on the book, I chose to say, well, when you're looking at a country as resistant to international human rights law as China, the best approach may be to focus on the SDGs as policy instruments for sustainable development, which at least rhetorically China supports, and to say, you know, if you, every document that we have, which I think supports your view, is if you ameliorate the conditions you're describing in the home, everything else in SDGs goes along with it. You improve access to food security, you improve access to health care, you improve climate change prevention as well as remedial steps. Everything that we have indicates that. And therefore, then the tool becomes convincing a state to do what you would think it wants to do, which is economic development, but use gender equality or parity, however you want to call it, to achieve that, never mind about protecting the formal human dignity that human rights is, or stuck in this international legal frame. And so what I suggest is, with some countries sometimes, and with some problems, depending on the context, you may be better off ignoring the law or saying, here's a tool that can get you to the same place in a different way. I also start with the bank, because I think the bank may be misguided in focusing on land titles, but boy, does it have money that could put in the right hands if it were also convinced that this was also in the bank's interest. So I totally agree with you that following down the line of Amartya Sen's notion of capabilities and how do we get to achieve capabilities is part of the solution. With respect to Marcia's comments, I think it is fair that all of international law lacks tools of enforcement. What we say about that is this is not another book on compliance, but that there is, at least Beth Simmons and a number of folks, who look at the dimensions of human rights law in terms of, let's look at what happened in country X as a result not just of what CEDAW said at the Geneva, but what happened through time, through its use in national courts. And that's why I stress particular progress on particular cases at particular moments in time, as opposed to trying to measure the impact. I also say in the book, cause and effect here is massively difficult. You could focus on the 16 countries that have changed their reservations policies or eliminated reservations on CEDAW, and many of them happened sometime after the CEDAW committee criticized them. But I am under no illusions that the CEDAW committee actually caused those changes. There were political circumstances, domestic civil rights, and other efforts. I happen to think that the most effective tool that CEDAW uses is tested by whether or not there is civil society, independent groups in the country to take this up. And when there isn't, or when the civil society groups are, as in China, state-sponsored, that is, they are the entity of the state, then you're back to your original problem that you mentioned. I do think that there is the prospect of more impact, but I also think that, to be fair, we have a ton of scholarship on the jurisprudence of these committees. And I think that it's time to pay as close attention to the jurisprudence of this committee just to see that part, even before we get to the difficult compliance issues, which are, I think, very hard to measure. I also take the point that it is hard to call property rights some of the things that CEDAW does. And I guess what we're doing there is to sort of push the concept of what property ought to be, in part because it is so fundamental to how societies structure themselves. So there's a measure here of purposely putting the box in the wrong hole in order to see whether that has a better prospect of pushing that. But I take on board also Darren's points about the binary. The only thing I would say about that is that it's built into the convention. There's only so much evolution. When the text says what it says, and it's against women, it's very hard, absent amendment, to achieve what I would applaud, which is to go around or through or bypass the perceived boundary. So that's all I want to say about it.